Okay, well, we'll go ahead and get this panel kicked off here. This is panel E, and we're going to go until 10 minutes till 5. The panel after this, we're going to talk about sales. So if no one buys your product or idea, you don't have a company. But this panel is going to focus on protecting that product. So asset protection, how to increase your company value. We're going to cover some taxes and credit issues that you need to think about. I know this is a small crowd, so we're definitely going to invite your questions, and we'll have extra time to cover that. So again, thank you for coming. Just a quick introduction of names and the firms that these fine panelists represent. Thank you to Marie Carley with BDO, who is a partner there, and she's going to be our moderator this afternoon. Tara Neely with Pulcinelli. Dan Crow with Bryan Cave. John Hickson from St. Louis Economic Development Partnership. And for those of you who attended the last panel, you'll recognize Geetha Sant with Washington University School of Law. So thank you, everyone. Marie, it's all yours.
Wonderful. Thank you, Michelle, for the introduction. So just so everybody's clear, we are competing with exits in the other auditorium. So I think that's why. And you guys all get the gold star because I think you're all wanting to make sure you get it set up right. And the exit will come later down the road. So well done. You all get my award for the day. And thank you, panelists, for joining me today. So we're going to have a very open forum. And again, with this small crowd, please feel free to jump in, ask questions. I encourage you all to interrupt each other and give your different perspectives because you all bring a very unique perspective. So again, thank you. So I thought we'd start off the panel with the kind of the threshold question of what is intellectual property? We're talking about asset protection, and with many startup companies, the main asset you're protecting is the idea of the business or the software or the intellectual property. So what is it and why protect it? So we'll start with that, and you can weave in, or we could do it later, what is copyrightable versus patentable? So kind of from a very 1,000-foot level, what is intellectual property? And Geetha, maybe we'll start with you at the end.
It's a great way to start off this panel, I think. Intellectual property, we tell our students in our clinic, is your idea, your method, your formula, something that is most likely the most valuable asset of your company, something that your company is based on, that it's a widget that you're perhaps making and selling. Ideas are not patentable, but it's an idea as well. It's an underlying idea. I like to think of it as it's your brand, it's your shtick, it's what you're going to be known for, whether it's tangible, in some cases intangible as well. So mostly in kind of an intangible form of who you are and who your company is. Is that a fair way to say it?
Sure. Yeah.
30,000-foot way to say it.
Yeah, that's great. I mean, you have two patent attorneys up here, Tara and myself. Well, we come at it from different aspects. She has a biotechnology and a life science background. I have a electrical engineering and software background, so we tend to see different types of inventions. But really, if you talk about intellectual property, there are 4 basic types: patents, trademarks, copyrights, and trade secrets. A patent is a negative right. In other words, if you come up with an idea and you file a patent application, you ultimately are awarded a patent, you have the ability to stop others, including your competitors, from practicing the same invention. So making the same product or performing the same process or using the same chemical formulation. So it doesn't give you the right to do anything. It's a negative right. It gives you the right to stop others. And one of the simple ways that I use to explain it is a chair. Imagine if the only thing we had in the world were stools. In other words, a place to sit with 4 legs. And Tara comes up with the idea, wouldn't it be great to put a back on it? Well, and somebody has a patent on the stool. She can get a patent on the improved stool because it's a chair, but she actually can't make that because her chair has a place to sit and 4 legs. So that's what I mean by a negative right. It would give her the opportunity to prevent anybody else from making a chair, but she herself couldn't make the stool or the chair. Now, in the real world, you would solve that perhaps by both of the patentees agreeing to license each other. So that's kind of the basics of a patent right.
I guess I'd expand a little bit on comments that both Geetha and Dan have made. Intellectual property is actually a pretty big umbrella. And within that umbrella, there are forms of registered intellectual property, and that's what we think of when we think of copyrights, patents, and trademarks, and it's usually kind of the first tools that come to mind. But it also encompasses unregistered forms of intellectual property, which are trade secrets and know-how, technical know-how, and show-how, that kind of thing. And there are ways that you can capture all of those, not just the registered IP, but also the unregistered IP legally. And those can all be assets that you can harness in any kind of transaction, whether it's with an investor or partner, or hopefully along the line a potential buyer. So we happen to concentrate in our practices, because we're patent attorneys, on the registered form of IP, which is a patent. But we also counsel clients typically on how to harness their intellectual property more broadly in other ways, whether that's by copyright, trademark, or trade secret protection. And by the way, all of those can be complementary to each other. So you have a well thought out IP strategy in a general sense would maybe incorporate elements of some or all of those pieces.
So I'm not sure that I understand. Why would there has to be some point at which you decide I need to protect my intellectual property, and some point short of that? What would be?
I'm just going to go there next. So that's the great next question. Thank you.
And I'm glad you asked. So, so number one, I think there's certain subject matter that lends itself particularly to certain kinds of intellectual property protection. That, for example, like the software, biotechnology inventions, the nature of the subject matter is patentable. But why would you go, just because it's patentable, why would you go? Because investors really want to see that you have thought this through and you have an active patent program, because that's one way, just as Dan was explaining, it's a way of keeping competitors out of your space for a while. It's a limited monopoly. It keeps your competitors out for a while, and it's a great thing to have depending on the strength of your patents or your patent portfolio. And same at a high level for copyright and trade secrets. There are other ways of keeping your competitors out of your space, at least for a while.
So what are some of the cons of doing that protection? Let's maybe first start with cost. What does it tend to cost to do the range of protection? So let's start with that.
So the major cost for me, for some of the clients we see in our clinic, is disclosure. So a lot of the registration, particularly in kind of patent or, except for trade secrets, by definition, by term, trade secrets can be confidential and there's no registration required, so there's no disclosure. But a lot of clients that we have in the clinic are a little unnerved by applying for a patent because they're not sure if it's quite prime yet. And you guys can talk a little bit more about, different kinds of patents as well, but they're worried about the disclosure. So in addition to the cost and the risk that you put it out there, I think the disclosure is probably the one fearful thing.
Yeah, building on that, so what she is saying is that when you file a patent application, you have to put in enough detail to allow someone who's in your field to be able to make and use the invention. So you got to spill your guts. And that application, I mean, there are exceptions, but typically that application will be published in about 18 months. And so if your competitors see your product out there, your service out there, and they are savvy enough to go look at the patent office, they may find your published patent application and see exactly what you're doing. So, one of the questions that I ask if I have an inventor come in is, well, tell me why you want to get a patent versus retaining it as a trade secret. Because, there's some cost with trade secret. In other words, you got to take some steps to maintain it as a secret, maybe have some non-disclosure agreements in place with your customers or vendors or employees, but it's typically a much, much lower cost than a patent. And the downside to trade secret protection would be it's not going to protect against independent development. Somebody on the other side of the country comes up with the same idea, or it won't protect against some kind of legitimate reverse engineering. In other words, if they can buy your product at Walmart, tear it apart, figure out how it works. But for software, based inventions, that can be a great form of trade secret. If you're talking about a manufacturing process where no one's going to come in to your plant and see what you're doing, maybe there is no need to get a patent.
And yeah, another aspect with patents is that it's not only the disclosure, but on top of that, you must have heard people say all the time, oh, you can, patents, you can just work around them. And what that means is that, what that's referring to is the fact that that patents have claims in them, and the claims can be analogized to let's say the metes and bounds that you would see in a deed of real property, but it sort of defines what you consider and what you've negotiated with the patent office as your intellectual property, and it has bounds on it, and those bounds are defined by the language of your claims. And you can get real fancy, as you might imagine, in how those claims are actually interpreted. And it's possible for a competitor to come in and actually basically work around your claims, depending on how broadly those claims are written. So that's another risk.
So, John, you tend to deal more in the advanced manufacturing space, and then you've had some business experiences of your own. So, your experience with patents, did your companies need to protect their intellectual property, or the companies that you work with, or less so because, again, they're manufacturing and it's more in-house private?
We chose to never patent any items. Most of our work was as a government contractor. So most of our work was going to end up either out in a public sector someplace, either as a real item that people could purchase and reverse engineer. And also they were overcome by technological advances as you go through. So probably anything that we made would be out of date before the patent would be out of date. So there's no application. Although I will tell you where we used patent information was obtaining copies of similar items to find out some unique aspects of that. And so that helped us compete around the edges sometimes. So when they talk about working around a patent, people do that all the time.
So neither of you
Can I
addressed...
ask the audience a question? So we've been kind of talking about patents for a few minutes, and we want to make sure that we're giving you the information you want. I mean, are those of you in the audience, do you have patentable ideas, do you think, or what kind of...
So who in the audience has an idea that might be worthy of a patent or a trademark protection of some sort? So a few.
So few.
Trademark? Okay. Okay. Great. Okay.
Trademark.
Trademark. So do you have a question?
Well, I had something to offer that
Yes.
I'm not exactly the right person to ask that question because I'm a patent agent. I patent things as an inventor. But the one thing that I think that I will counsel some inventors, which I think you patent attorneys would probably agree, is that the patent database, other than just figuring out whether you can patent something, the reason it exists is it's a fantastic learning library. You have to disclose stuff so you can learn how to do the things you did. So if you're doing a product or something, you have problems figuring something out, look at the patent database, talk to a professional that can help you find stuff, even if you don't think you're going to get a patent, because you can learn so much and you can find the solution to your problem for a $1,000 search or two that you could not find otherwise. I mean, there's a lot more than just getting the protection while talking to a patent attorney.
Yeah, I mean, I would underscore that by saying that nowadays it's so easy to hop online and the free searching tools that are available to do that, and you don't even have to be particularly sophisticated in searching. It's very easy to do with basic keyword searching to find out a lot.
It's even easier
Yeah.
to take PTOs.
Yeah,
although
it's
not
great.
quite as complete.
So none of the panel addressed cost, and maybe that's because it's all over the board, but give us some sense of what cost might be.
Yeah, for a patent, so you're going to take it from a range of a basic mechanical invention. What you're really paying for is the attorney's time to write the application. So you may, for a real simple mechanical, might be in the $3,000, $5,000, $6,000 range. At the larger end, the business method, the software, biotechnology, those tend to be closer to $20,000. But there are ways that you can, reduce those costs. Because again, what you're paying your patent attorney to do is to sit down, understand your invention, and write up the disclosure and review the prior art. You guys can do a lot of that yourself. You know, we talked about you can go out and research what we call the prior art, in other words, what exists before, what patents are out there, understand where your invention fits in that. You know, I've put a back on a chair, I understand exactly what I'm doing. And then you can sit down after having looked at these patents and begin to write it yourself. And the more that you can do versus coming in and just meeting us in our office with nothing but an idea in the back of your head, that can substantially reduce the cost.
Well, one of the things I'll tell you is Washington University and St. Lucie University both participate in a program with the USPTO. WashU does the Patent Pro Bono project, so if you qualify, you have an idea but don't have the resources to do the patentability check or the prior arts check, you can come to Washington University and they'll help you do that. Again, you have to qualify through the USPTO for the pro bono. And to the extent that, you know, we can do the prior arts review, and then if it is patentable potentially, we send it out to outside counsel, and they do that with the USPTO pro bono project on a pro bono basis. And then St. Lucie University Law School has a similar program for trademark. So if you have a trademark, you're a startup, you're a fledgling business, you know you've got a really unique logo, a name, or intersection of both, and you want to protect that. You know, Washington University provides that as well if you qualify for the clinic in other ways, but St. Lucie University also works directly with USPTO to work on those issues. So those are two free resources for you guys to at least get your toes in the water, you know, and then kind of file for the prosecute the patent.
And for those who are a little bit further along, or when you get to that point, and I don't know if this has maybe been covered in some of the other sessions today, but the sort of ecosystem, the entrepreneurial ecosystem in St. Louis is really well developed. If you're kind of plugged in at all to kind of the local news and so forth, there's just a lot of reporting on the ecosystem here in St. Louis. And part of that ecosystem are these competitions and incubators that, and accelerator programs that will link you up to a whole host of resources that include, for example, competitions where part of the award is in-kind services from local law firms. And so I know we service a number of startup clients that have been awardees in these competitions and help them get started with a lot of their IP needs. They take the in-kind award and apply that to some of their IP needs. The other thing I would say is that we talked a little bit about trade secrets, and there's a lot of technology that you know, you might initially approach as potentially patentable or the subject of a patent application. And a lot of that technology can be very adequately and well covered by a trade secret approach, and that is very cheap. There are some downsides to it. Once the cat is out of the bag, it's a done deal, and you may have a basis for some monetary recovery depending on how the cat got out of the bag, if it was misappropriated by somebody. But if it's something that's very difficult would be very difficult for a competitor to reverse engineer, you can maintain trade secret protection potentially indefinitely for the cost of instituting robust security measures within your organization. So that can be really cheap and can be effective depending on the technology.
Michelle.
Could you give us some ideas of that? I mean, I just picture like Willy Wonka's chocolate factory, you know, like, oh, we don't know, or Hershey's, you know, we don't know I mean, can you give some real world examples of trade secrets? And how do we even know if those companies have a trade secret? Like, we know if they have a trademark because it has a little R, you know, but what are TM?
Yeah, from the outside you wouldn't necessarily, from the outside you wouldn't necessarily know. Okay. There's no database of trade secret protection or anything like that. But having said that, that doesn't mean that it's not very much a property, an asset that can be worked into agreements, transactional documents of various kinds. So it's very much something that you can point to in your private negotiations, your private transactions. And it would be, examples would be, and I'm sure Dan can give other examples, and Gita as well. I mean, the classic one that everybody mentions is the formula for Coke.
Coca-Cola.
But I mean, typically in kind of my universe on the biotech and chemical side, it tends to be internal processes, manufacturing processes, purification processes, kind of formulaic type of stuff that from the outside, the commercial product, you can't figure out, you know, what they're doing to get to that point.
One example we've used in the classroom as a former client, making candy. And they
So Willy Wonka?
It was Willy Wonka. I wasn't supposed to disclose that, but thank you. So, you know, when Willy Wonka comes into the clinic and says, hey, we've got, nobody else would know what was going on in the process of putting caramel and chocolate. What was the process was and this is actually out in public, so I can talk about it, but was putting it on a cold frozen marble slab. Something about the cold slab made it harder before the chocolate got harder before the caramel got harder, or whatever. It was more chewable and chewy. And so the trade secret is now out in the open, but it was the trade secret for that company for a very long time. Nobody would know it except for somebody who was entering into an agreement to say, I have a non-disclosure agreement. This is a trade secret. You know, you can't go to a competitor. If you do, you're not going to disclose or use this trade secret, and it's enforceable to X limits or whatever. But something like that, that's a process that is, just looking at the candy, you wouldn't know that the chill made the chocolate harder and the caramel softer. You know, so that kind of thing.
So I'm going to shift gears for a minute. So we've been talking about protecting your company's information and holding it very tight and putting a bubble and wrapper around it. So let's shift gears and think about, as we heard in various presentations today, there's a robust ecosystem and everybody's encouraged to, early on in the company's formation, start to draw in future investors and draw in future collaborators and maybe your future team members. And in order to do that, you have to share. You have to share your idea. So the question is, how deep do you go in sharing your idea? When are non-disclosure agreements necessary? When are they a waste of the paper that they're written on? So talk some about more sharing and how that can help a company, but where do you draw the line? So John, I'll start with you on this one. What's your sense of sharing?
If it has value in the marketplace, then you need to at least make a conscious decision about it. I guess that's, I don't know how else to say that. Whether you're discussing it with potential partners or investors or even high-level employees, you need to be cognizant that what you're revealing may have some value in the marketplace, and you need to take whatever steps are necessary appropriate to the level of risk.
I would echo that as well. I think, I mean, from a lawyer's perspective, your lawyers are always going to be more cautious. And as soon as you're talking about anything of value, I would say don't share until you have a non-disclosure agreement in place. There may be occasions where having a non-disclosure agreement in place isn't particularly worthwhile in the case of you have a partner that is just, you can't enforce it against. If it's just, you know, if you're dealing with somebody like that, I just don't know how you can necessarily protect yourself. But I would say, other than those sorts of situations, always have a non-disclosure in place. And they're pretty basic and you know, they can be drafted for a pretty low cost.
And maybe even beyond non-disclosure agreement, having something in your employee contracts as well is probably
absolutely
critical.
And that would be part of, for example, a kind of a program for trade secret protection. Having your employees aware of what you consider to be your proprietary information is an important part of that. As soon as you're talking to, even just internally, have everybody know what the plan is.
And that can include customer lists or prospective customer lists.
Any kind of business information, really.
Employee handbook, if you don't have an employment contract. Not everybody's going to have an employment contract, but employee handbook that applies to all employees, whether contracted or not.
And is that binding, legally binding, if it's in your...
That's a really good question.
Yeah.
So it depends. I hate to be that lawyer that says on the one hand, on the other hand. But, you know, if drafted correctly and given at the right time for the employee to review, parts of it can be binding. But as long as you state you're still an employee at will, this is not a guarantee of... So there's a little bit of give and take for guarantees and, you know, exchange for that kind of.
So one of the things to think about when you're entering into an NDA, depending upon the circumstance, would be maybe you need to disclose your idea to a manufacturing company. Maybe you need to disclose it to an investor. One of the things to do is to think about ownership at that point in time. Because a lot of times when you disclose your idea to somebody else, they'll be able to build on it and help you and improve it. And you want to be thinking about that up front. You know, if I give my idea to a manufacturing company, will they agree that I own any improvements in terms of changing the product for manufacturing purposes? You want to just think about those things up front because, you know, if the product is successful, then you might have your customer, your supplier, your manufacturer come in and say, hey, actually, I own a piece of that.
If you're making any money at any point, they will come back that they own a piece of it.
On a kind of a theoretical, you know, kind of the academic side, if you will, there has been, would you guys, the patent lawyers, agree, there's been some movement away from patenting everything in fact, I can't even say some movement, there's a very big movement to kind of go to what you were saying. If it's useful for the marketplace, if it's useful commercially for our country, for our economy, for our culture, the movement is to not patent it. And the PTO is getting a little bit stricter, a little bit more, this should be in the public domain for the welfare of the community or the culture. But there's been a movement away, I think, kind of an academic movement away from patentability.
It'll be interesting. On the way here, I heard that the Supreme Court ruled today in favor of patent rights and the ability to enforce patents, so maybe it'll shift back the other way. I don't know, but I was like, wow. Well, so the last question on IP, and then we'll open it up to other questions, is so what do your investors want to see in terms of having your patent intellectual property protected? And when you go to an exit, what will your buyers have wanted to see that you've done in terms of protecting that IP? So Geetha, we'll start with you.
Vigilance and enforcement. So that really kind of, to me, those are the two phrases that cross from patent to trademark to copyright to trade secrets. That's kind of the two words, I think, that that the patent holders or they want to make sure that if you're going to use your patent, as we were saying earlier, that it's a negative right? So you kind of have a patent that basically means you can't let somebody else use it. How are you going to know? So you have to kind of keep up on your product and your patented widget and to see what else everybody else is doing, or else you're not going to be able to stop them if you don't know. So vigilance, and if you see it once and you decide to ignore it, you're not going to be able to try it again later. It's going to be a lot tougher for you. So enforcement. Each and every time you see something that you believe that it's protected by the negative right of a patent, and even trademark. I mean, I want to make sure we talk a little bit about trademarks. We had some interest in the room with that. Vigilance and enforcement. You have to be consistent with looking at it. And I think that's what second stage investors are coming in and saying, what did you do? So you have this patent, what are you doing with it? And how are you maintaining that negative right that you have, or with the trademark? You know, the most famous one in St. Louis is this really fabulous Italian restaurant, by the way, out in West County. It was called Bellagio. And the place in Vegas, Bellagio, said, no, change your name. And these guys are like, we're a family-owned Italian business, Italian restaurant. You're a huge, place in a hotel, whatever, and casino in Vegas. Bellagio enforced and was vigilant and pursued. Now I think the restaurant is called Il Bellagio. But that's an example. Why would Bellagio, the casino, care? It's because of vigilance and enforcement. You have to be vigilant and you have to enforce anything that you see that infringes on your rights.
You know, one of the investors that I do some work for, his main theme is, I don't want to buy a lawsuit. I don't want to invest money that is going to lawyers to defend a lawsuit. So he cares less about whether you have a patent on your product, for example, as you have the right to sell that product. So, clearing your product so that as soon as you hit the ground running, you're not going to get hit with a patent lawsuit by somebody else. Same thing with trademark, that you've picked the name of your business, that as soon as you open the doors, you don't want to get that cease and desist letter and have to change.
Yeah. I would say, really just expanding on what Geetha and Dan have just said, is that the twin peers for most investors are, what is your strategy as far as your IP? Do you have a well thought out strategy? Maybe it doesn't involve patents whatsoever, but at least you have some sort of answer to how you're going to keep competitors out. whether it's by trade secret or what have you. Maybe it's not a subject matter that's really subject to trade secret or patent protection, but it's more a branding approach. So what is your strategy for keeping others out at a high level? And then also, what's your clearance in terms of other people's IP? What have you done? Have you checked out the landscape at all? Do you have any knowledge of what your competitors are doing? Are you stepping on other people's toes and not knowing it? So have you checked on these things, and do you have answers to these sorts of questions when the investors come knocking?
Okay, so any questions on intellectual property? And we're going to shift gears if we don't have any. Yes.
I know it's really very early, probably too early to be sure, but new trade secret legislation, is there any practice tips or whatever you found that might vary how you would evaluate what would or would not be patent protection? I mean, this is kind of, I know patents, but this is beyond really my purview, and I'd be happy to learn if there's anything you guys, it's so early, but.
It is early.
I mean, I think all I would say is that, with that law, that we can expect that there'll be more people interested in pursuing trade secret protection. And I mean, as Geetha said, I think there are a lot of issues right now in the U.S. patent landscape that make patents perhaps slightly less attractive than they were, 5-10 years ago. But I don't think that the basic analysis changes as far as whether your subject matter is appropriately protected by.
I was thinking more like new advantages to find a way to protect things with the trade secret approach, where you may not have had the ability to protect it properly, quite right with patents, or quite right, I mean, just some new opportunities possibly to find ways to have a little more protection, anything that popped out to you.
From a practical perspective, it's not that different now, or yet, maybe I should say. I do foresee some, changes coming in terms of what kind of documentation we can do to kind of reinforce the trade secrets. But right now, it still comes down to reinforcement kind of in the traditional ways that we've already had with the NDAs, with the agreements. But I think the key factor for when we try to make that decision with clients or with other organizations within WashU is to really figure out, what is it that you want at the end of the day? Do you want, to keep people that know you away from using what you have, or do you want to disclose it to the public and kind of have a bigger swath of people that you want to protect yourself from, or exclude, basically is really the word. I don't know if we've seen any trends yet on any changes in kind of how we would document the trade secrets or how we would treat that differently. I think it's coming. I do think it's coming.
So maybe with that, we'll move on. Kind of the next section is going to be on finance, and we'll do a little bit on tax. Oh, please, yes.
One more question on NDA.
Sure.
Marie, you said earlier there's a lot of confusion from the various panels today. Some people say you don't need an NDA, you can be very open, sharing your ideas. So for a brand new startup, when you're going into your pitch and you're dealing with your first or maybe even your second round of funding, in your experience, I mean, I don't think the investors want to see NDAs. That's sort of what I feel. What's your advice? You just forget it? You just share the ideas openly with everybody?
Well, I think it's probably a matter of trust. Do you know these investment groups? Do they have the reputation that they're going to listen to your pitch and not disclose it? So I think if you're dealing with reputable investors and they don't want the NDA, then
half of them will walk away from it.
Half of them walk away. That is absolutely my experience. Maybe more than half.
If I could just comment on that as a follow-up, my previous role was with a venture capital firm. So what they want to see in your initial pitch is non-confidential information. So in your initial pitch, come with information you can share with all of us here in this room. Don't go into the details of your methods of patents and et cetera, et cetera. The next time around, if it makes sense, and you're pitching them again, they're very willing typically to sign an NDA. It's just that you don't want to limit yourself the opportunity to get in the door at least.
Exactly.
Because they don't have the administrative assistance to deal with NDAs for everybody who wants to pitch them. Hopefully that makes sense.
Well said. It all depends on how deep you go.
And don't lose sight of the fact that NDAs are just very viable with not just investors, but with anybody that you deal with. Don't forget that.
Okay, so to shift gears for a moment to talk about, I'm sorry, absolutely.
Just real quick, along those same lines, are there standard terms and conditions that you recommend for startups that you've seen?
Yeah, most of them are, if you just did a search and pulled some up on Google, most of them are pretty standard. The one piece of advice that I would get is they usually have a section where they define confidential information, and usually it's something that is completely broad, all ideas, inventions, customer lists. If you really I would advise you to put what your secret is right there. Not what the secret is, but, I consider my formula, my ingredient list, to be a trade secret. Put that right there.
Yeah, I would say you want to, you can certainly take kind of a template form. They're pretty basic type of agreements, and for non-lawyer types, they're actually mostly pretty readable. But you definitely, I like to see some specific language in there that describes the specific purpose of the exchange of information, the nature of the information being disclosed, and whether there are any samples actually changing hands. I also tend to, there's usually some sort of, this is getting a little technical, but there's usually a choice of law provision in there, and you preferably pick something that is kind of neutral, like Delaware or maybe New York.
Can I ask a question?
Yeah, exactly. If the person you're dealing with is out of New Hampshire and they're pushing for New Hampshire law or something weird like that, it's like, try and pick something that's a little neutral.
Delaware.
Yeah, Delaware.
John?
Yes. My question is, how does someone pick a lawyer? You
To
each
help
have
with
different
IP
strengths. We
protection.
have 3 excellent choices right here, obviously brilliant legal minds, but how does someone know if you're the right fit for them?
I would urge everybody, and I think all the clients that I work with, most of them undertook an actual interview process, just like any professional I think you want to work with. You want to have, the key is to have a really good relationship such that you feel like your communications, you're on the same page. You're not sort of talking past each other, and that your style of communication is kind of the same, that you're just on the same page. You want to connect with that person. And, we're all different people and have different, styles of communication. So I think it's kind of a fit, is the way I see it.
So I'm not hearing so much about that they know the depth of your technical area, like plastic molding. It's not that as much as just, is it the right person fit?
I think there are a lot of good people in town who have, comparable technical experience, and, you can find out the level at which you're going to be able to assess that is information that is pretty readily available. And I think the key thing is, among the possible choices, do you connect with that person? That would be my advice. I don't know.
Okay.
I would encourage, we talked about just this issue in the last panel, but encourage you guys to figure out resources for those, legal services, interview them, ask them questions. And to me, the bottom line always is kind of what you were saying is somebody's going to champion your business model, somebody who's going to share your business vision, and they're going to be your supporter and rallier, not just a black and white ivory tower lawyer that's going to give you the legal answers without helping you fit that legal answer into the work that you are doing in your company.
So we have about 7 minutes left, I'm thinking. So I'm going to ask each of you to think about what advice would you give with respect to financing your company, spending your money, or since you're all missing the exit conference next door, if you have any great ideas from an exit perspective. So I'm going to give 2, because as moderator, I get the right to jump in on this one. So one is starting the first quarter of 2017, research tax credits are now refundable, and they've never been refundable before. So I won't go into the qualification or anything, but if you're doing something new and interesting and have wages or any services, think about getting research tax credits, and they can be a credit against your payroll taxes starting quarter 1 of 2017. So that's awesome, really good news. And then the second, totally shifting gears, is on your, yes, go ahead. Federal. Yeah, because there have been state credits. Missouri Works are refundable and sellable, but the federal have never been refundable before. So that's really cool. The second, yes, go ahead.
Just a quick question. Can you, perhaps on the same expenditure, take the R&D tax deduction and the credit?
Absolutely, absolutely.
You can actually get an investor a profit.
Correct. Money in their pockets. Yes. Yeah, you take a haircut on the credit if you take the deduction, but yeah, you get both. Yeah.
Would that be enough to like balance out that it's a net zero?
Absolutely. It's computationally a net zero.
So you get to zero, but you won't get a profit?
Well, no, sorry, you will get a profit. So you take the credit, or you take the deduction to get your income to zero, and then you get this refundable credit. And the credit's a little bit less than if you hadn't taken the deduction, but it's still a credit after zero. Yes, yeah. With all kinds of qualifications around that.
And does that carry forward?
And it carries forward. Yes. So then second suggestion I'll make, totally unrelated, is when you bring investors into your company, they talked a little bit about keeping the term simple, but keep your cap tables small. So if you've got friends and family and sisters and uncles that all want to invest in your business, and there's 25 of them, have them come in as one investor. So they come in as one partnership that has one vote and one representative that can ask questions of anybody, as opposed to having 25 and then adding 25 more later. So I see some heads in the audience. People have experienced that nightmare. So those are my two suggestions. So John.
No replacement capital is going to come into 25 family investors. So what she says, double it. I mean, it's just, you don't need 1 million people. The question was, I know I have to spend money in my company. How do I know where to invest it first? And so to that, I've discovered that most people who want to start a business start by thinking about how they're going to spend money. I need to spend money for this. I need to buy that. I need to go here. I need to do. Start by thinking about your customer. If you want to be successful, get some money in the door first before you rush out and run yourself ragged trying to spend money. Think about your customer first. Figure out where the money's going to come from.
Suggestions?
This is sort of by way of taking the question and turning it into a question that I really want to answer another question that was asked.
That's allowed.
But I'm not really an expert on financing, but the clients that I work with, the startup clients that I work with, I think many of them, a vast majority of them at this point, have really been successful at getting to the point of some significant financing by basically leveraging the local, getting back to the earlier comments about the local entrepreneurial scene. And what many of them have done is actually, so they get plugged in, they've gone through some of these competitions multiple times before actually being one of the, the primary winners. And they've leveraged the in-kind services, and then they've gone on to another different competition here in town. They are very, very plugged in to local events here in town, so they're always talking to people. They're going to Venture Cafe, they're going to the Million Cups, they're
MVF, going to MVF.
Yeah, and MVF, and really, really sort of networking the heck out of it, being out there, leveraging these competitions, going back and, if you don't win the first time, many of them have done this repeatedly, and it's like the third or fourth time that they actually end up being winner. They go on to another one, and they're just building on these successes. And those sorts of successes are really great when you are at the point now, you've built up all these successes, you can go to, an angel investor or, even better, venture, and say, look at this track record that, you took baby steps to get there, but you've got an incredible record to show them.
So Dan and Geetha, final thoughts on finance or?
One thing I would say is when you're evaluating what your IP is, be very broad-minded. You may think this widget is going to bring you $1 million, but let's start with, is there a historic cost? Is there a historical value? Is there a replacement value? Are the other different methods of valuation? Think about those. Work with an accountant agency, certainly, but be real and be authentic with your valuation, because that initial valuation is going to carry you forward and is going to carry forward with whatever levels of investors and investments you get. That base value that you provide, think of it as almost like a tax basis, but that is what's going to be the initial value. You grow on it, but we'll always have to remember that initial value. So value that initial IP very, very carefully.
Dan?
No, nothing else.
Awesome. Well, thank you so much for joining us. Michelle has some closing comments.
Yeah, I think everyone can hear me, actually. This is pretty great acoustical room. So thank you, everyone, for participating in this. I think it was a lot of the things that the panelists suggested are perfect segues to our panel F. So please join us in the auditorium. We're going to talk about why it's so important and critical to get your customer and land your sales, and then our networking will begin. And another plug for MBF. I mean, we're key sponsors for this program, and it's all about networking. So thank you, and please consider joining.
Thank you.